Hello and welcome along to today's webinar, 6 Steps to Hiring and Firing. My name is Rachel Lamsley and I'm a Senior Employment Law Advisor here at Ellis Whittam. So today I'll be helping you navigate through some important steps to get right when it comes to hiring and firing. We run a full day course on this topic, and so if you are looking for a bit more detailed information on the subject, then do get in touch. So, what are we going to take a look at? Well, we're going to take a look at a life of an employee. We're going to take you through recruitment, making an offer of employment, different types of contracts, short service dismissals, fair reasons to dismiss, and finally settlement agreements. So lots to be getting on with. But what are we going to take a look at first? Well, that is recruitment. So a very important step is getting recruitment right. I can guess what some of you might be thinking. Recruitment can take so much time out of your day, and actually we just need to plug a gap and get somebody in as soon as possible. Anything more than that really is too much effort. And I hear you on that. And this is why we try and help our clients as much as possible to make this a smooth process. Having a good recruitment process can help you get the right person for the role and your organisation. And it can save you lots of time and money if things go sour and the employee becomes difficult, which might have been picked up as part of the recruitment process. So let's have a look at 4 areas to help you with recruitment. The first one being plan. The key to a good recruitment process is getting the job description, advert, and person specification right. This applies to all roles within your organisation, and we can help you with that. This stage helps you focus your mind on what you're recruiting for. Do you need the role? What does that entail? What does this person specification cover? For example, what qualifications, experience, skills, or aptitude and attitude are you looking for? Preparing your job description and person specification should be done together rather than in isolation. So this brings me on to preparing. How are you going to test the applicant to see if they suit you and the organisation, as well as the role that you're putting them into? When you have a look at this, what did you mean when you said you needed to be a good communicator or have excellent written skills? Plan out how you're actually going to test the applicant. For example, are you going to interview with a particular set of questions? What about a presentation or a test perhaps? Or are you going to be reviewing their CV for the answer? Having competency-based questions on how the applicant deals with situations could help you expose any problematic issues with the new employee. Now, don't forget to ask relevant and considered questions to the applicant and ask the exact same ones to every person. This shows a consistent approach, but it also helps you avoid discrimination. Despite how much you want to know the answer, it's not reasonable to ask a woman of a childbearing age what her plans are for children if she's considering getting pregnant soon. If we do that, discrimination bells may soon start ringing. The last area from a recruitment perspective is making sure that you compare those employees or those applicants to one another, rather than just picking out the one that you prefer the most. If you properly compare, you can actually see where the weak areas are. A top tip for you is have an application form. Rather than asking the candidate to simply send a CV in, as you can actually compare like for like. Asking the same questions or even having a presentation on the same subject also allows you to compare. If you've got a key role or a managerial position, you might decide to go one step further, and that could be to consider something like psychometric testing. If it is important for you to understand somebody's personality traits, then why not look into that option? It perhaps doesn't give you the absolute be-all and end-all about that individual, but it certainly gives you some detailed insight into that individual. So, going through an effective recruitment process can take time, but we can help from the preparation right the way through to training how to manage that process and provide you with interviewing tips. So the next step in hiring and firing is making sure that your offer of employment is right. This can iron out a whole host of issues before the individual actually starts working with you. If a job applicant is successful at interview and you want to offer them the employment, then it's important that the offer is made subject to terms set out in your standard contract of employment and any other conditions that are important to you. For example, getting a satisfactory DBS check if that's relevant and required, or perhaps the employee being free from restrictive covenants with their previous employer. Remember, a contract of employment does not have to be in writing. It could be agreed verbally over the telephone or perhaps face-to-face, and so care does need to be taken over discussing the offer or the terms and conditions, as that sort of contract of employment could be established by verbal discussions. Making an offer conditional on a number of points allows an employer to withdraw the offer if the conditions haven't been met. You may therefore ask the employee to provide you with evidence of particular qualifications, and always ask them for evidence of that right to work. It might also be quite important to your organisation to obtain satisfactory references. If you take up references for every new employee before employment starts and you receive useful information in response, then that can be really helpful in confirming your recruitment decision. It is common to make your job offer conditional on the receipt of satisfactory references, and you should ensure that the contracts of employment allow for termination in light of unsatisfactory references also. It is worth bearing in mind, though, it is increasingly evident that employers are reluctant to provide references that go beyond confirming job title and employment dates. This means that it's less likely you're going to be able to rely on helpful references and puts a premium on a good recruitment process, as we discussed it. Just remember, there is prohibition on employers asking employees for information related to their health before making an offer of employment. That extends to asking third parties such as referees for that information, so don't get caught out by that. Moving on then, a step that we should certainly not be skipping is providing the right type of employment contract. This should form part of your offer of employment process. We do need to clear up a pretty good question here though before we get started. Does an employer actually need to provide employees with a written contract of employment? Well, first things first, the contract of employment sets out the rights and obligation of both the employer and the employee. As mentioned earlier, contrary to popular belief, a contract of employment doesn't have to be in written form to be legally binding. It may be written and signed document, but equally it could be a verbal agreement. If you enter into a contract of employment verbally, you are, however, still required to provide each employee whose employment is to continue for more than 1 month with a statement of written particulars of employment. That's got to be provided within 2 months of the employee's start date, and there's a long list of things that you've got to include within that document. So do take advice that you don't get caught out. If you do, there can be a cost to the organisation, so it's worth making sure you don't get this wrong. A little note for you here, do all of your employees that you currently employ have contracts of employment? Now, there are numerous types of contracts to choose from, so let's take a look at a few here. There are things like indefinite contracts. This is the most common form of contract used to run your core business activities. You might hire someone on a permanent full-time or part-time basis and pay them, say, weekly or monthly. Just on this, make sure that if you select this contract, it works for you and your business. For example, really consider what hours you're offering to that individual. Do you need to provide longer notice periods, perhaps because they are business critical? There's also fixed term contracts. This is a contract that ends on a specified date or when a particular event or task is completed. Fixed-term contracts can be very useful to cover a period of, say, maternity leave or long-term sickness, or perhaps where there's a job to do when funding has been provided, or even to undertake a specific task or do some seasonal work. So they are quite a helpful contract to consider. There's also the well-known zero-hours contracts available. A zero-hours contract is a contract between an employer and an individual whereby the worker or employee has no guaranteed hours and is only paid for the work that they actually carry out. This means employers don't need to give them work, and the worker or the employee doesn't actually have to accept the work that's been offered to them. It allows employers to have a pool of people available and allows the business to respond quickly and effectively to any fluctuation in business demands. For example, to an unforeseen event, or cope with absences, or in the build-up to a busy period. We also have apprenticeship agreements or contracts. This is a different type of apprenticeship and contract that's actually available and something that you're able to give out. These are frameworks of apprenticeship, or they might be approved English apprenticeships. In addition, there are modern apprenticeships which carry with them full enhanced protection. Depending on the type of agreement, different provisions need to be included and different rules apply in Scotland. Honestly, my expert tip here is if you're thinking about employing apprentices, perhaps even with the apprenticeship levy in our site, then there are a number of things that you need to make sure you put in that contract of employment to protect the business and avoid giving an individual enhanced protections that we don't have to do. Always seek advice when taking on apprentices, because you don't want to get caught out with any nasty surprises if you do decide to dismiss them perhaps early on. The final one I wanted to just point out was there are things like directors' service agreements. When employing people as directors, you should draw up a director's service agreement which covers duties, restrictions during employment and pay, for example. Do note, there might be additional issues to cover off in the agreement if you're a PLC or perhaps working in a regulated sector. For example, the financial services. So take advice to make sure that you're getting this right. What is key to remember in terms of employment contracts is that it needs to suit your business and reflect the offer of employment. We can work with you to make sure that you're giving the right contract out and to make sure that it meets your business needs. It's a key step in the hiring process, so it's always worth making sure you get this right. So, we've considered the steps you need to get right when hiring, but what about firing? Why is getting that right so important? Well, to name just a few, employees can bring claims for unfair dismissal, discrimination, or whistleblowing if we wrongly fire someone. With the abolition of the fees, claims are going to increase significantly through the tribunal, and the only people who are going to have to deal with this are the employers, who need to defend many, many more claims than we've had to in recent years. Unfair dismissal claims, for example, well, they carry a fairly significant financial penalty if employers get it wrong. And unfortunately, it's not a defence to say that we didn't know the law or perhaps believe something that turned out to be incorrect. Claims for unfair dismissal carry a basic award, which is equivalent to a redundancy payment, and a compensatory element that's capped at either 52 weeks gross pay or just over £80,000, whichever is the lowest in that situation. This means that, from an unfair dismissal perspective, you could be looking at quite significant amounts of money. The mean unfair dismissal claim in 2015-16 was just under £14,000. Not an attractive sum to have to pay out if we get it wrong. But the story doesn't end there. What about discrimination, whistleblowing, and perhaps raising health and safety issues? These types of claims don't actually require 2 years service like the traditional unfair dismissal claim does. If an employee brings a claim for discrimination, well, those losses are uncapped, and so it really is up to a judge, taking into account the evidence of what compensation is to be awarded. Discrimination awards can go from anything from hundreds to hundreds of thousands, depending on the severity of the claim being made. In 15-16, the highest award for sex discrimination was £1.72 million, with the mean being just over £85,000. Can your organisation really afford to wrongly discriminate? So let's have a look and see if we can help you get this right. On to firing. Step 4 is to have a look at short service dismissals, perhaps the closest thing to a magic wand in an employment law context. But as with everything in life, there is always a catch or two. So let's start at the beginning. If an employee has no previous continuous service with you and they've not reached 2 years service, then the starting point is that they do not have the rights to bring a claim for unfair dismissal. Thank goodness, a good amount of time for an employer to work out if their employee suits the organisation. A few things to consider though, and here we come with the first few catches. Firstly, let's take a look at contracts and handbooks. There's a couple of reasons for that. We need to check their start date, and if this is anywhere near the 2 years service mark, and certainly anything say within a month, then take advice on it. The right to bring a claim actually kicks in a little bit before the anniversary date, and so you don't want to have fired an employee only to find out that they actually had service to bring that claim. The second reason to check out the contract or the handbook is to ensure that you don't have any contractual obligations to go through a particular disciplinary process or to provide any lengthy notice periods that have a financial impact on the business. Ignoring either of these could result in a breach of contract claim, which you might want to take advice on before taking the plunge. Something to always bear in mind is whilst an employee cannot bring a claim for unfair dismissal, as we said earlier, there's a whole raft of other claims that don't require 2 years service. And you can trust me when I say that employees will try and throw as much as they can at you in the vain hope that something will stick. As I said earlier, discrimination claims are uncapped and they are for staff with protected characteristics. So, what are protected characteristics? Well, there's a whole list of these, and these include race, sex, disability, age, pregnancy, maternity, sexual orientation, gender reassignment, religion or belief, and finally, marriage and civil partnership. So, not the short list. And it's quite easy for an individual to try and start saying that action you've taken has been because of one of those reasons. If a difficult employee alleges that they've been treated less favourably on the grounds of, say, their sex or race, they can try and bring that claim in the tribunal. If an employee alleges that that's the reason, then we might still be able to dismiss them, but obviously we just need to make sure that we're going through a fair process, so one to take advice on. Finally, whistleblowing is also a pretty big issue, and that is one of the automatic unfair dismissal rights that an employee has. This again kicks in from day one. So even though they may be short service, we've still got to consider the impact a whistleblowing claim may have. They can be a real risk for your business, and so if employees have raised concerns or any issues with you, it's worth running those past your advisor, as they often don't say, oh, by the way, I'm blowing the whistle, or I'm raising a health and safety issue. Short service dismissals really can work for you, particularly if you identify an issue early on. My best advice is don't let it drag on or ignore a festering problem or ignore any grumblings or issues that an employee is raising. Believe me when I say 2 years comes round very, very quickly. So if short service dismissal doesn't work for you, how do we look to fairly fire an employee in other ways? Well, as long as you conduct a fair process and have a fair reason for a dismissal, you've got a good chance at defending a claim. So what are the fair reasons to dismiss? Well, we've got conduct. We've also got capability qualifications, or also known as performance. We've got redundancy, breach of a statutory right, and some other substantial reason. Let's take a look at a couple of those. Firstly, dismissals for conduct reason. You would dismiss an employee for misconduct by following your disciplinary procedure. So what are some top tips for you? Well, first off, let's identify who's going to run each stage of the process. Ideally, you need somebody to run an investigation, somebody different for a disciplinary, and somebody different, again, for any potential appeal. Once established, that investigation needs to be kicked off. Now, make sure the investigating officer is not connected with the issues at all. They need to be impartial and fair. We also need to ensure that investigations are carried out without unreasonable delay. For example, if somebody broke the rules a couple of months ago and we were aware of it, did nothing, and now want to tackle it, then it's perhaps not going to be very reasonable and could result in an unfair outcome. As part of the investigation, you want to get an account from that employee. Don't forget, you also want to collate evidence of the wrongdoing. So consider things like witness evidence or documentary evidence. Is there any other type of evidence that you need to be looking at, perhaps a process or a procedure that they haven't followed? From a disciplinary hearing perspective, if we're dealing with low-level issues, we're more often than not going to set this up as a potential first written warning. For something more serious, such as fraud or theft, and if your procedures support it, you might be looking at setting this up as gross misconduct, where the potential outcome is dismissal. Remember these key points for a disciplinary hearing: the right to be accompanied, sufficient notice, a written invitation, making sure that it contains all of the requirements, and the evidence. Each of these elements make up a fair process, and without any one of them, you could land yourself in bother. Why not let your employment law advisor draft that letter up for you? Don't forget, once a decision has been made, we also need to confirm that outcome in writing. What about capability or qualifications, or also known as performance? Well, we've got a few tips here for you in respect of that. The starting point in respect of performance issues is don't let it get out of hand without doing anything about it. If you've tried an informal approach and there's been no significant change, then hold an investigation meeting whereby we find out the reasons for the behaviour and why there's been no improvement. If you're unsatisfied with the responses, then you perhaps progress to a formal performance management meeting with the following requirements. We'd be looking at the right to be accompanied, notice of at least 48 hours, a written letter of invitation setting out the allegations of poor performance, and finally evidence of the issues. This is when documentary evidence is key. We need to prove that there's been poor performance. Following a formal performance management meeting, you then provide them with a written outcome and perhaps what we call a performance improvement plan, or PIP. This allows you to set out very clearly the objectives or areas for improvement and allows you to stay on top of the issues that you're experiencing. If the targets are then continually failed or more performance issues arise, then you move the employee through the process, giving them perhaps a final written warning, and then move to consider dismissal with notice. The process isn't completed overnight, but there's no need to wait months and months for the employee to improve, nor should you be waiting and vain hope that the employee will improve of their own merit. Discuss with your advisor what's a reasonable time frame to wait and move along as soon as you are able to. Don't forget that as part of any formal procedure, such as disciplinary or performance management, we need to give the right of appeal after every formal outcome. So remember to factor that in when identifying who's going to do what and any potential timeframes. Finally, a couple of pointers on the other areas, such as redundancy, breach of statutory duty, or some other substantial reason. These can be tricky, and a fair process to avoid a tribunal claim is an absolute must. Do therefore make sure that you're going to take some advice before setting out down one of those routes, because you don't want to end up in a situation where an unfair dismissal claim is issued. So, after all is said and done, you might feel that there's no other alternative but for somebody to leave your organisation, and you want to have a clean break. One of the options, therefore, might be to consider a settlement agreement. This could be the answer for any difficult employee, and it could lend itself to a quick and less painful route if perhaps you are able to bring that employment to an end sooner rather than later. But as with everything, there are a few considerations when deciding to offer a settlement agreement. Firstly, let's have a chat. What is a settlement agreement? Well, ACAS gives us a very neat definition. Settlement agreements are documents which set out the terms and conditions agreed by those involved. So, in this case, an employer and an employee. In the agreement, they agree to settle potential employment tribunal claims or other court proceedings. What is worth bearing in mind is that in a good number of settlement agreements, there is a financial incentive for the employee to sign the agreement, or at the very least, some form of payment in inverted commas in return for entering into the agreement. Say, for example, a reference. Those would be considered consideration. Once agreed, settlement agreements are legally binding and they can waive specific employment rights, such as unfair dismissal. An employee therefore needs to take independent legal advice to make sure that that agreement is binding. Now, these agreements are voluntary, and in most situations, the negotiations are confidential or off the record, which means that they can't be relied on or referred to should you end up in front of a judge. It is really important, therefore, that employers take the right steps when engaging in these conversations to preserve that off-the-record status of the conversation. Saying something that's discriminatory or perhaps putting undue pressure on an employee to accept it is a certain way to lose that off-the-record status. Now, whilst I would love to do so here, we could talk for another hour on the without prejudice rule or protected conversations and when they can be used. So do get in touch with us if you're thinking about embarking down that route. A few important things to take away with you in respect of settlement agreements. Firstly, the timing of a settlement agreement offer is important. If a settlement agreement falls apart before signing on the dotted line, employers really need to consider what impact this has on the continued working relationship. It may feel somewhat awkward having to work with someone who you've just indicated to that you want to terminate that employment relationship. Whilst a settlement agreement can be offered at various points in the employment relationship, they are voluntary negotiations after all, and so we are not necessarily in a surefire way able to terminate that employment relationship. With all that being said though, settlement agreements can be an excellent tool to get a business to where it needs to be quickly. And so if you're considering this option, I would certainly suggest you work through all of those aspects with your advisor before commencing those conversations, because you don't want somebody to try and rely on them after the event. We actually assist our clients with this every day, and we draft these settlement agreements up as part of your service with us. As experts, we can help you get down and set off down the right route, so do get in touch if that's something you're interested in. So let's round up on some of the things that we've talked about today. Some top tips: get recruitment right. If you can do that, it really helps employers get the right people for the business in the right role. Make sure managers undertaking recruitment are trained so that they can spot some of the traits of difficult staff or somebody who's not going to fit in with the organisation. For key roles, consider going the extra mile, perhaps looking at psychometric testing. Get your offer of employment right. References can also be useful, but this will help set out everybody's understanding of the offer at the outset. Provide the right contract. It sets out the expectations and avoids any confusion should an issue arise later on. Take advantage of using short service dismissals. If somebody isn't right for the organisation, can you look to dismiss them sooner rather than later? If you are going to go through a dismissal process, perhaps with somebody who's got more than 2 years service, then do make sure you've got a fair reason to dismiss as well as going through a fair process. And don't forget, you do have the option of settlement agreements, a tool that might be very, very helpful for you and your organisation. So before we sign off, just to let you know, we have released our free seminars in October 2017. We will be having a look at managing disciplinaries to avoid tribunals, unravelling the complexities of key health and safety legislation, and we will be up and down the country where you will be able to meet the experts. So why not go along there to www.elliswhittam.com/seminars to register for your free place. Now that brings us to the end of today's webinar. Thank you so much for joining me today. I've really enjoyed having you on board. If you've got any questions, then do pop them in the questions section and we'll be able to come back to you after the event. At EW, our employment law advisors and health and safety consultants are on hand to help you understand your legal obligations and make any process easier and smoother. So if you've any questions about today generally or our services, then get in touch. Our contact details are right there for you and they'll be in the follow-up email. Our next webinar is on 0 hours contracts on the 21st of September, and we have our monthly news webinar on the 29th, so do feel free to join me on that. I hope you have a great day.